ladies and gentlemen. Thank you, Your Excellency, Professor Dr. Rahmat Mohammed, for the kind invitation. It's a great honor and a pleasure to address this distinguished body. I think the last time that I attended an ALCO annual meeting was in Cairo in the early 1990s. I must make it clear that I'm here in a personal capacity, not as representative of the Commission in any formal sense. Let me begin by saying that I greatly appreciate the fact that ALCO is organizing a half-day session on the International Law Commission. I think your interest in our work is much appreciated. I apologize, Mr. Secretary General, if I stray a little wider than the three topics selected for particular attention this morning. What I'd like to do is three things. Firstly, to mention some ILC-related matters which do not actually arise from this year's session, but which are current. Secondly, I'll briefly describe the session in 2013, focusing on those areas where comments from states would be most welcome. And finally, I'll speak on the three specific topics which you've chosen as a focus for this session. I'd like to begin by paying tribute to ALCO's contribution over many years to the development of international law. I see that you held a special meeting in March this year to commemorate the 30th anniversary of the Law of the Sea Convention, as well as a session yesterday. The law of treaties is another topic to which ALCO made a significant contribution. But I would like to mention an even earlier project. Professor Gerhard Haffner has recently written that ALCO led the way with its work on state immunity in the 1950s. It was the first intergovernmental body to work in a general way on that important subject. And at your third session in 1960 in New Delhi, ALCO considered a report which proceeded from the premise that a state which enters into a transaction of a commercial or otherwise private character ought not to enjoy immunity from proceedings in other states' courts in respect of that transaction. And eventually, the seeds that were sown by this organization bore fruit with the adoption by the UN General Assembly in 2004 of the United Nations Convention on the Jurisdictional Immunities of States and Their Property. A number of ALCO members played a major role in this exercise. There was Ambassador Sompong Sucharitkul from Thailand, Ambassador Egiso from Japan, who were very distinguished special rapporteurs. And more recently, the late Ambassador Chusei Yamada from Japan, whose passing we mourned earlier this year, played a central role, as did China and India in the final negotiations. A number of ALCO members have already signed or acceded to this important convention. Those that have ratified or acceded include Iran, Japan, Lebanon, and Saudi Arabia. And in addition, China and India have signed the convention. I do hope that more ALCO members will join this convention in the near future, thus continuing to lead the way in this important field. And 2014 marks the 10th anniversary of the adoption of the convention, and that would be a good date to aim for. Perhaps ALCO might make this a special topic for its meeting in 2014, with a view to encouraging participation in the convention. I'll now turn to the Commission's first reading draft articles on the expulsion of aliens. This draft was completed in 2011 under the wise leadership of Professor Kamto of Cameroon, and states have been requested to submit written comments on the 32 draft articles by 1 January 2014. The Commission will then conduct a second and final reading in 2014, and we will do so in the light of the written and oral comments of states over the years, but particularly in the light of their written comments to be submitted by January 2014. So it's essential that comments be received in good time if we're to be able to take them fully into account. And I'm sure I don't need to stress the importance of this sensitive topic of expulsion of aliens and the importance for governments of getting the draft articles right and the importance for the affected individuals. So I would urge members of ALCO to submit comments in writing on expulsion of aliens by the end of this year. And the third topic that didn't come up this year in the Commission but will come up this year in the 6th Committee of the General Assembly is the Guide to Practice on Reservations to Treaties. This was adopted by the Commission in 2011, but for one reason or another has not yet been debated fully in the 6th Committee. Last year, Hurricane Sandy prevented the debate. The Guide to Practice is a monumental work, and comments on it will be of great interest and of great importance. I only have time to mention two matters. Firstly, there's the difficult question of Guideline 4.5.3 on the status of the author of an invalid reservation in relation to a treaty. This deals with what is perhaps the most difficult and the most contentious issue of the law of reservations. Is a state that makes an invalid reservation a party to the treaty without benefit of the reservation, as some would maintain, or is that state not a party to the treaty at all? Paragraph 1 of the guideline makes it clear that the decisive factor is the intention of the state making the reservation. That is the principle. However, paragraph 2 then raises a rebuttable presumption. The reserving state is considered to be a party without the benefit of the reservation unless it has expressed a contrary intention or such an intention is otherwise established. These two paragraphs, which are the essence of the Commission's proposal, are, in my view, balanced and workable. And the commentary explains that this guideline largely corresponds to the progressive development of international law, and that it would therefore seem expedient to let the practice evolve. The guideline was adopted by the Commission without dissent, and it was adopted after careful study of the practice and case law, taking into account the views of human rights bodies and the comments of governments. Practice to date, as I've said, has been divided on this matter, and in my view, members of ALCO could make an important contribution to achieving more legal certainty in this area of reservations if they could speak in support of the Commission's proposal in this guideline in the 6th Committee this year. The second point I want to mention about reservations is the possible follow-up action by the General Assembly this year. There are really three elements. Firstly, the Commission has made the modest recommendation that the General Assembly should take note of the guide. That should not, I hope, be problematic. Secondly, the Commission has set out in an annex to the guide 9 conclusions and recommend that the Assembly call on states and organizations, as well as monitoring bodies, to pursue a reservations dialogue, that is an informal dialogue with the reserving state to try and resolve the problems in a pragmatic and transparent way. I think, again, that shouldn't be problematic. And finally, thirdly, the Commission has recommended that the Assembly adopt a mechanism of assistance to states in relation to reservations. I think that's perhaps a bit more complicated, but I would urge you to look at what's in the report and take a position on that proposal in the 6th Committee. So I now turn to what the International Law Commission did this year. You already have a thorough background paper prepared by the Secretariat, and the Secretary General summarized what it did just now. But I would add one or two personal comments on some of the topics. The topic of subsequent agreements and subsequent practice in relation to the interpretation of treaties may sound a very technical one, and it is in a way, but it's a very important one. It covers all kinds of subsequent agreements and subsequent practice, the way treaties develop over time, and we have proposed 5 conclusions with detailed commentaries prepared by Mr. Georg Nolte, the rapporteur, and examined and adopted by the Commission. They do include some important points. For example, one issue is the role of subsequent agreements and subsequent practice in relation to a possible evolutionary interpretation of a treaty when a term develops a meaning over time in the light of practice. The Secretary General mentioned the subject of provisional application of treaties. There was not yet a great deal of progress on this topic, though we had an interesting discussion based on the rapporteur's first report and the very helpful study by the Secretariat. It's really a very good study, as are all their studies, on the travaux préparatoires of Article 25 of the Vienna Convention on the Law of Treaties. I think the subject of provisional application is potentially a very interesting one for states. It's politically interesting, and I hope that the Commission's work will assist states in understanding this concept. We've added a new topic, protection of the environment in relation to armed conflict, at the proposal of the Swedish member, Ms. Jakobsen, who is the special rapporteur, and we look forward to her first report. I think this is something that states will want to look very carefully, but until we have her first report next year, there's not much to be done. Very importantly, the Commission added a new topic to its agenda, protection of the atmosphere, and appointed Professor Shinya Murase of Japan as special rapporteur. This proposed topic had proved quite controversial, and it was included in the Commission's work programme on the very last day of the session on the basis of certain important understandings put forward by Professor Murase. And you'll find these understandings set out verbatim in the Commission's report. A working group under Ambassador Kriengsak Kittichaisri of Thailand continued its consultations on what to do with the topic obligation to extradite or prosecute. A rather detailed report is annexed to the Commission's report in the hope of eliciting reactions in the 6th Committee on the future of the topic. Should we continue with it, or should we stop it? And if we continue, what should we do? The Commission describes how the topic developed. It analyzes the judgment of the International Court of Justice last year in the Belgium versus Senegal case. It does not deal with the question whether the obligation to extradite or prosecute is already a rule of customary international law, at least in relation to certain crimes. There was a general view that that was something that it would not be helpful for the Commission to address. Not helpful, I think, because we would probably conclude that we didn't know the answer, and that would, or that there was no such rule, and that would set back the development of customary law and freeze it, which would not be welcome certainly to many human rights bodies. The Commission has added a topic, crimes against humanity, proposed by our American member, Professor Sean Murphy, to its long-term program of work. The idea is to prepare for the General Assembly draft articles requiring states to prevent and punish crimes against humanity and to cooperate among themselves to this end, principally through